Hi, my name is Paul Skeith, and I'm a business lawyer practicing in Austin, Texas. This week, I'm sharing some tips and thoughts about how to effectively handle disputes that arise after the sale of a business. Disputes are likely inevitable in any M&A transaction, especially where there are differences in expectations, interests, or interpretations between the parties involved. So, in other words, almost always. Disputes can involve different parties such as sellers, buyers, shareholders, lenders, regulators, or third parties. Some of the most common causes of disputes that I've seen in my practice are breach of the purchase agreement, representations, and warranties by the buyer or seller, third party claims against the seller, earn-out or contingent payment disputes, purchase price adjustment disputes, working capital adjustments, tax liabilities and splitting the tax liabilities, intellectual property rights, lurking employment or labor issues, and regulatory compliance issues. To prevent or minimize disputes, it's important to have a clear and comprehensive deal agreement that covers all the material terms and conditions of the transaction, and also to include a dispute resolution mechanism that specifies how any disputes will be handled. It's also important to conduct a thorough due diligence process to verify the accuracy and completeness of the information provided by the other party so there are no surprises, and also to identify any potential red flags or deal breakers up front. I also suggest that it's important to maintain a good relationship with the other party throughout the entire deal process and to communicate openly and honestly about any concerns or issues that may arise after the deal closing. If a dispute does occur, it's best to act quickly and proactively to resolve it before it escalates or affects the value or performance of the deal. You can use various methods to resolve disputes, such as negotiation, mediation, arbitration, or litigation. The choice of method depends on factors such as how complex the dispute is, the relationship and trust between the parties, and the time and cost involved, as well as the desired outcomes of both parties. In conclusion, post-M&A closing disputes are likely inevitable, but through careful planning, these disputes can be contained and dealt with efficiently in a way that gives all the parties the deal that they originally bargained for.